Supreme Court is reconvened.
Please be seated. Good afternoon. Welcome back to the Washington Supreme Court for our third and final case of today. Today is June 13th of 2024. We're here in our temporary facility in Tumwater with Justice Whitener on the screen remotely to my right. And that final case is in re the dependency of ZA, SAA, and SMA. Opening is Kristen Velour for 15 minutes. The response is split between Tara Ers for 14 minutes and Moses Okeyo for 6 minutes, with 5 minutes reserved for rebuttal. Counsel, please proceed.
Good afternoon, Chief Justice Gonzalez, and may it please the Court. Kristen Velour on behalf of the Department of Children, Youth, and Families. By its plain language, RCW 1334-130, subsection 6A, does not require either clear, cogent, and convincing evidence or a manifest danger. Instead, the legislature intended that the preponderance of the evidence standard of proof apply at dependency and disposition hearings unless it expressly provided otherwise. Application of the preponderance standard at disposition also satisfies procedural due process due to the significant safeguards in place, both at a disposition hearing and in subsequent dependency review hearings. The Court of Appeals erred by adding words to this statute, and this Court should reverse and remand for further proceedings. The only issues this Court accepted review of are whether subsection 6A requires clear, cogent, and convincing evidence and a manifest danger. Neither MA nor amici dispute that the plain language of the statute does not include these elements. Instead, MA and amici challenge the meaning of the term available within subsection 6A, but this Court denied review of that issue. And the Court of Appeals here did not interpret the meaning of available below. Instead, it restated its holding in WWS, where this Court also denied discretionary review of the meaning of the term available. Because this Court did not accept review of this issue, it is not properly before the Court today. So looking to the statutory language, RCW 1334-130 subsection 6 provides that a court may place a dependent child in out-of-home care at disposition only if the court finds, in part, that there is no parent or guardian available to care for such child. Subsection A does not include the words manifest danger or clear, cogent, and convincing evidence. Those elements are found only in subsection C. Reading clear, cogent, and convincing evidence and a manifest danger into subsection 6A, as the Court of Appeals did below, would render subsection C meaningless. If clear, cogent, and convincing evidence was the standard of proof for all dispositions, the legislature would have said so. But instead, it distinguished subsections A and B from subsection C.
Can I ask you a question, just as I look at, and I'm kind of parking the WWS case, which I think your argument relies pretty heavily on, or the Court of Appeals did as well, but if you look at the difference between A and B and then C, and your argument is that C is the only provision that would include the clear, cogent, and convincing, preponderance would apply to the lesser. There's a lot of logic to that if A and B are not really qualitative assessments, but C is, as to the appropriateness, as to the child's safety, as to maybe something that's akin to best interests, or that under C, we have the direct expression about manifest danger. But they're more qualitative, that's a more qualitative assessment. That's maybe not the right word, but a fact-dependent assessment about risks to the child. B is up or down. So there seems to be some logic in reading A as up or down, available, not available, that physical presence requirement. So could you address that in that context, that plain language, I understand your argument. It doesn't say clear, cogent, and convincing. It doesn't say manifest danger. But there's also some logic to the appeal that's because it's not about those qualitative assessments about the risks that placement with the parent might pose.
And 2 points to that, Your Honor. The first being, the statute does not provide simply that there's no parent available. It's no parent available to care for such child. So it means more than physical presence. You have to have more than being present in the courtroom at disposition to care for the child. And then also looking to the framework that the legislature set out for subsection 6, a court still must make a finding as to A and B, and then a finding as to subsection C. But subsection C is framed differently than A and B, in that both A and B reference a parent. But subsection C does not. It's not focused on the parent or the parent's role in regard to this family. It's subsection C refers to the family home. So the harm that a court may be assessing is not limited to the harm a parent might pose. It could be someone else in the home. And there are examples of this with fentanyl, for example, where it's highly potent synthetic opioid that can cause really significant harm due to limited exposure to a child. And there could be someone else in the home, such as a grandparent, an older sibling, who is using fentanyl, and a child is subject to exposure of that substance. That child is still at a very real, manifest danger of serious abuse or neglect, even if their parent has no deficiencies that lead to that harm, or the parent is otherwise able to ensure their basic needs. Another example we might see is if you have a sibling that is abusing maybe a younger sibling in the home. That parent is not deficient. They're faced with an impossible choice. They have an obligation to both of those children, but there is still, nevertheless, a manifest danger of serious abuse or neglect to that younger child in that home that could warrant out-of-home placement under the statute.
Can I ask you a practical question? So let's say a parent is there in the courtroom who has a home, says, I'm available to care for the child. How does a court determine whether that's true? What facts bear on that assessment?
And the statutory framework of 1334 informs that. So when we look at the wording of 1334 subsection 6A, a parent available to care for such child, is the parent able to care for the child? But there's more that informs that, as was expressed in WWS, where the question really, before we even get to out-of-home placement, is can this dependent child be safely placed in home with services that ameliorate a safety risk? And if not, then we move to subsection 6, and the court would evaluate whether that parent is available. We have case law stretching since at least 2011 was the earliest case that I was able to find that has consistently determined that available means more than physical presence. There is no appellate court that has held that it is limited to physical presence. And this is significant in the context of child welfare proceedings, because when we look to subsection 6C, it's really rather narrow. It references serious abuse or neglect. And abuse and neglect are statutorily defined terms that can be found in RCW 2644.020. And abuse is limited. It is limited to sexual abuse, sexual exploitation, physical injury. So that would not that would not take into consideration situations where children might be suffering serious emotional or psychological abuse that does not result in a physical injury. And it cannot be that the legislature intended that those children be returned to a parent's home simply because they are at the disposition hearing. Similarly, the definition of neglect is negligent treatment or maltreatment, and that definition expressly excludes exposure to domestic violence. So you might have a child who has been exposed to domestic violence in the home. This court has recognized that that leaves very significant psychological scars for that child, even if it's not physical, and that child themselves is not abused. But that child could be returned home to the abusive parent because they are in the courtroom, and that simply cannot be. When looking to the context of 1334, the legislature expressly declared their intent in 1334.020, where the child's health, safety, and welfare is of paramount concern, even overriding a parent's legal interest. So that paramount concern in the child's health, safety, and welfare is always the first consideration, even when it comes to out-of-home placement at disposition.
Would you concede or disagree that there's overlap between a fact pattern that could be addressed either under A or C?
Yes, Your Honor.
And so if you have a lower burden of proof, if there's an overlap, wouldn't the state always opt to pursue the lower burden of proof under A instead of C?
No, Your Honor. If a fact pattern meets either of these subsections, the child is at risk of harm, which warrants out-of-home placement. But it's the court that makes this finding based off of the evidence that's produced at a fact-finding hearing, where there is the application of the rules of evidence, and then also at the disposition hearing, the social study that the department provides, taking all of this information, considering the circumstances of the family, to see whether one of these subsections are met. But they do not operate at the exclusion of each other, and they are disjunctive. So any one of these findings does warrant out-of-home placement under the statute.
So, counsel, I guess I have a follow-up question to that, because what I'm struggling with in terms of making sense of the statute is that if you, as you said, if you get to subsection 6, that means that the court has already concluded that out-of-home placement is necessary. So that means they've already decided no parent is available. So what does A mean if that's the case? Because as I read it, that whole chunk, before you get to A, B, and C, is the analysis the court has to undergo, reasonable efforts, et cetera, to say, okay, we can't return home. So I'm trying to understand how that statute can be read to give any meaning to A if the court's already decided we're at out-of-home placement.
I think the answer to Your Honor's question is that if a court is ordering a child in out-of-home care under subsection 6A, that means the parent is not available, but also not available and neither in-home services nor, in-home services don't ameliorate that risk. The parent remains unavailable, even if in-home services were to be provided. And that's what allows for the out-of-home placement, that the in-home services would not ameliorate the risk to the child or the jeopardy to the child's health, safety, and welfare.
Could we be talking about different homes? I mean, I think that's the situation here, right? I mean, that the parent who maybe is being assessed as to this more qualitative assessment of availability isn't the parent from in the home that the child was removed from?
That's true, Your Honor. And in this case in particular, this father had deficiencies that still jeopardized the child's health, safety, and welfare, even though the primary risk came from the mother and her significant substance abuse and mental health issues. And those deficiencies, as the court found below, were that he was not able to adequately protect the children from the mother and did not have really an understanding of how the mother's behaviors had impacted the children. And they had very real responses to the mother's actions. 10-year-old ZA researched how to commit suicide on a school computer and had very significant emotional reactions to the mother's behavior. And the father was not able to adequately address that or to prevent any additional harm that the mother may pose. The Court of Appeals below found that substantial evidence supported that the father would allow the mother unfettered access to the children and that he was not an adequate protective force from the mother.
And is that A or C?
Here it is subsection A that the father has those deficiencies, as the court found, the inability to protect, the lack of insight that jeopardized the children's health, safety, and welfare.
But you acknowledge that there is overlap in that fact pattern, and the court could have found either under A or C, under your argument.
There could be if the court were to find that there was a manifest danger of serious abuse or neglect. And for this case in particular, changing the definition of available would have really significant impacts. And the department would ask that this court remand to the Court of Appeal, or the trial court. 2 years have elapsed since this disposition hearing at issue to determine if the evidence, the facts present now, would meet that standard. But at the time, the trial court was operating under the definition of available, meaning that a parent has deficiencies that jeopardize the child's health, safety, and welfare, and found that that was met here.
Could a trial court say, I'm making this finding under A and C?
Yes, Your Honor. And that's within the statutory language. We do see that A, B, and C are disjunctive, but the statute does not say that the court must find only one basis. It can find multiple, and sometimes does, based on the facts before it.
They're not disjunctive in terms, an out-of-home placement may be made only if the court finds. So I guess maybe I've been reading the statute wrong all along. You're saying there can be out-of-home placements without any regard to manifest danger.
Correct, Your Honor.
So you could, it kind of goes back to the Chief's question, so you could do a lighter touch on some of those same considerations under A and never have to face the clear, cogent, and convincing burden standard or the manifest danger standard.
Yes, Your Honor. And again, subsection 6C is very limited. So that would be limited to not only abuse and neglect, which have those more limited statutory definitions, but serious abuse or neglect. But subsection A still means that a child is, their health, safety, and welfare is jeopardized or threatened by the parent. And the legislature determined that that is sufficient to warrant out-of-home care under that preponderance standard. And that makes sense, too, when we look at subsection 6C, how it's not limited to a parent's actions. That means that a child could be placed in out-of-home care due to someone else's actions. And that still has a very real impact on the parent's rights to custody and control of their child, which is why the legislature imposed that higher standard.
The definition of availability found in WWS, we denied review. The legislature has since amended that very section of the statute, have they not?
They have not amended subsection 6A. And if I may continue, I know I'm into my rebuttal time. There have been 5 amendments to 130 since the appellate courts have first determined that available means more than physical presence. The legislature has never changed the definition of available, has never narrowed it. It has stayed the same. Thank you.
Response, please.
Good afternoon, and may it please the court. Tara Urs of the King County Department of Public Defense on behalf of amici in this matter. I intend to address the legal issues in this case and the profound impacts they'll have for all families in the dependency system. My colleague Mr. Okeyu, will address the facts of this specific case and the impacts this decision will have on this particular family. This position is a different and separate event in a dependency case from a finding of dependency. A finding of dependency does not even need to be made, the court does not even need to find a parent unfit to establish dependency, and a finding of dependency can be made solely on a preponderance of the evidence. But at disposition, which has a separate hearing, it has a separate statute, it has a separate court rule, one of the things a court can do is remove the child from the care of their parent and place that child in the care of the state, and thereafter, the state gets to direct the upbringing of the child. This court has never held, and should not now hold, that the state can separate a child from their parent on a mere preponderance of the evidence without any showing that removal is necessary to prevent harm to the child. The trial court here erred by applying the wrong legal standard, and this court can correct that error in one of 2 ways. First, the court can affirm the Court of Appeals ruling, which imposed the minimum constitutional guardrails on the definition of available. The Court of Appeals took the definition of available, but required that to be shown by clear, cogent, and convincing evidence, and required a manifest danger.
I apologize. Chief,
I don't know what that sound is. Any idea?
Virtual is just a pause the time. Virtual is
I think that's Speaker Chief.
it's a speaker right there.
Okay. Let's stand by just for a moment. Apologies for the interruption, both from
I want to be able to hear everything.
I'm going to trigger this off and see if that will help.
clear, cogent, and convincing evidence, and a showing of manifest danger. In the alternative, this court could adopt what we believe is the more natural, plain language reading of the statute that limits the word available to its most natural first definition, which is to be present or physically present.
Didn't we not take review of that question?
Yes, but you have taken review of this case, and the question in this case is one of statutory interpretation. And this court has repeatedly held that in order to interpret a statute, you have to consider it as a whole. And considering the statute as a whole means we can't read subsection A separate from subsection C. We have to harmonize the statute. And so in order to reach a resolution in this case, this court is going to need to determine how, if at all, the definition of available differs from what is contained in subsection C. And so
Counsel, I'm still confused by your argument because you seem to be saying if there's a parent available, then the court should order the child go to that parent. But that skips the first part of 6, which presumes you found or says, okay, an order for out-of-home placement may be made only if the court finds X, Y, Z, and that there's no parent or guardian available to care for such child. So it's already those. I don't understand how, like, your argument is sort of the flip side of the state's argument, and I'm still struggling to understand what the point of A is if the court's already gone through the analysis that exists in 6.
yes, and this is not a model of legislative clarity. The first sentence, that's section 6, actually talks about relative placement, and when the court can order relative placement. And then the remainder of that front matter focuses on the efforts of the department, the reasonable efforts the department should have made in the time period between the shelter care hearing and the dispositional hearing. But it is A, B, and C, which are the only parts of the statute that focuses the court's attention on the parent and the parent's conduct. And so if the court is contemplating, if the state is asked for removal of the child, they're going to have to show reasonable efforts and either that the parent is not available, that they are not willing, or by clear, cogent, and convincing evidence and manifest danger of serious abuse or neglect. And if they can meet the burden of showing one of these 3 by only saying the parent is not available, whatever that means, that leaves trial courts with completely unbound, unlimited discretion to separate families without a requirement of showing any harm to the child and on a mere preponderance of the evidence. And as the Chief Justice says, there would never be a need to reach subsection C of the statute because every case would be analyzed under the no parent available standard.
Can I ask, I had asked a question about, the home and the parent may not be the same thing, but I think you would disagree with that, or with the answer to that you would see that this throughout section, paragraph 6, A through C is talked about the home with the parent.
Yes, so disposition is always about the parent's conduct because the parents are the people in the court who are parties to the case and whose rights are being adjudicated. And so it's obvious that subsection C must apply both to the parent's conduct and to their inaction, and the things that are happening in their home. And we know that because if we take a look at subsection C, which says abuse or neglect, that takes us to the definition of abuse in 2644-0201, which then takes us down to 2644-02019, which is the definition of negligent treatment or maltreatment. And that tells us that negligent treatment and maltreatment can be an act, a failure to act, it can be conduct, it can be a behavior, it can be that leads to a danger to the child's health, safety, or welfare.
Ask a follow-up because I think you took the point of my question yet further even than I meant it. Let me give a fact pattern and see if that doesn't distinguish A and C, at least potentially. Let's say you have a parent and we have a problem with the requirement for housing. I'm not sure that's even needed, that you have to have a home to be able to parent your children. Putting that aside, let's say you have a parent who has a home and has resources, there's a room for the child, there's food in the fridge, but they're not willing to actually give the kid any of it, and they make them sleep outside if they misbehave, or in the wintertime, and other bad behavior. Wouldn't that only be under C because there is a parent available to care for the child, they're willing to take custody, they're just abusing, neglecting, or otherwise they're treating the child?
And if the court found that, then the child will be removable on that basis. The court would apply subsection C.
Under C only.
Under C only.
but you said that you never need to get to C, you'd always go under A. And I'm thinking, well, this fact pattern I've just thought up would be an answer to that assertion.
So our analysis suggests that in order to have there be some line between A and C, in order for those things to mean, for the legislature's intent to have expressed two different ideas between A and C, that they have to mean something different from one another. And if we were to limit subsection A to being present, to being physically present, so for example, not deceased, not defaulted, present in court for the dispositional hearing, then we can move, then that is an up or down analysis. The court doesn't need to make a finding by clear, cogent, and convincing evidence because they can tell they're here or they're not here. They're asking for their child back, they're willing. We know up or down that they're here or not here. But then if the parent is present and asking for their child and the state wants to see that child removed, they have to meet the definition of subsection C.
Asking us to disavow WWS.
Yes, there's two alternative ways the court could approach this case, and one would be to disavow WWS. And I would like to take the analysis in WWS and it's on its face. The concern that the court was trying to address in WWS is that there's some scope of parental conduct that is dangerous to children, but not cognizable under subsection C. And because there is that scope of conduct, what we need to do is to broaden the definition available to encompass that conduct. There's two problems with that. The first is that when you look at the definition of negligent treatment and maltreatment, so what is contemplated by subsection C, you find these acts or failures to act and psychological harms or any danger to the child's health, safety, or welfare is included already in subsection C. So the conduct that the court WWS was concerned about is already protected if you look at what's available under subsection C as an option for a court to use as a basis for removing a child. So the court in WWS, though, recognized that available didn't have any other words associated with it, and so had to find other places to draw from in order to add additional words in order to create a legal standard. And the court then borrowed from the legislative declaration at 1334-020, which has these same words. It actually has health, safety, and nurture, I believe, instead of health, safety, and welfare. But it's essentially the same. And so what the court did in WWS was to adopt a standard that was overlapping with the standard in subsection C. And the state has failed to offer an explanation for why an additional conduct, why there needs to be additional conduct contemplated under subsection A to protect children that is not protected under the definition of negligent treatment or maltreatment. And today the state said that would be psychological harms, but that actually, the definition of negligent treatment and maltreatment doesn't say anything about it being limited to physical harms. And in fact, when the legislature wants to limit the court's attention to physical harms, as they do in the emergency removal statute, emergency removal is only authorized when it's necessary to prevent imminent physical harm. You see the word physical in the statute. The word physical is not in the definition of negligent treatment and maltreatment. It clearly contemplates emotional or psychological harms to the child. And so what we have is a definition of available that the state's offering here is so broad, it would swallow the need to ever apply subsection C. A narrow definition of available would leave you with kind of up and down, easy determination that the court would be easy for a court to find. It wouldn't need to be established by clear, cogent, and convincing evidence. I'd like to focus the court's attention on how the state's argument here would allow for family separation based on poverty alone for the first time. I'd like to start by drawing the court's attention to State v. Rash, that's cited by Amici in this case from 1901. In that case, this court said, home life is too sacred to be violated, even by the law, without most pressing cause. It has been the long tradition of this court to protect the fundamental right of family integrity. The state's brief repeatedly talks about the definition of available that they're offering as the failure to meet the failure to meet a child's basic needs. The most common way our clients are unable to meet their children's basic needs is financially. If that is the standard, the mere inability to meet a child's basic needs based on poverty alone, we are cognizing family separation based on poverty.
Can I ask you to, though, respond to the point that we don't get to this paragraph 6 analysis unless we previously looked at what services are necessary to get to that ability to meet basic needs?
So the services part of that analysis in the top part of subsection 6 we're talking about That's about the state's efforts. So that's an analysis of whether the state made reasonable efforts. And I think the court might be looking at that unless the health, safety, and welfare of the child cannot be adequately protected in the home, that last line of that top part of subsection 6, that actually applies to the whether prevention services need to have been offered or not offered. And so, yes, the court does need to consider whether reasonable efforts were made, whether services were made available by the state. But the court also must consider the parent's conduct and whether the parent's conduct is going to cause harm to the child prior to separating a family. And it is by applying those next elements that we get to the question of whether it's the parent's, what of the parent's conduct is or isn't causing harm to the child.
Could you, there's a disconnect for me between the poverty argument, disconnect for me between the poverty argument you were just making. It seems as if you shifted away from that because if it doesn't matter if it's the state's conduct or not, because if the state is required to provide services, resources, whatever it may be, doesn't that answer your poverty question?
Well, it didn't for the legislature because they specifically called out poverty as not being a basis for family separation in the definition of negligent treatment or maltreatment. So we have the definition of negligent treatment and maltreatment that poverty alone cannot establish the basis for family separation. But if you never have to reach that definition because you're not applying subsection C, you're not applying neglect, you're not applying negligent treatment or maltreatment, you're only looking at whether the child's available because available means something broad and completely undefined, then you can separate based on poverty, even though the legislature specifically said they didn't want to separate children based on poverty. They didn't want to separate children solely based on exposure to domestic violence. They didn't want to separate children because they were sharing a room. But if the trial court never has to apply that subsection of the statute, if they can only ever apply the subsection about being available, then the court would never have a need to then that intent of the legislature to confine, to cabin judicial discretion around family separation would never be applied.
Well, I guess if we agree with your argument that subsections A and B need to be, or at least A needs to be measured by clear, cogent, convincing evidence, I guess why have C? I mean, it seems to me one way or the other, we're sort of taking A or C out as having a separate efficacy.
So one of the arguments we've made is that the statute says the court that the parent's not available or not willing, or the court finds by clear, cogent, and convincing evidence. We really think the best reading of the statute is that available is meant to be a self-evident determination, and that's why it's different from C. Available is, are you here? And if you're here, we can move on to subsection C. Now, I recognize that to uphold the Court of Appeals decision, we would end up with a standard where A and C looked a lot like one another, which is why we think a more natural reading of the statute would cabin subsection A to being merely physically available. That said, the court would have to wrestle with some very significant constitutional issues to allow family separation for the very first time on the basis of a mere preponderance of the evidence and without a showing of harm to the child. And as this court said in In Re Custody of Smith, the fundamental right to family integrity is only protected when the standard the state must prove to invade that fundamental right is showing harm to the child. And when the standard would be just, are you available to care for your child without any additional guidance about what available might mean, when the state says merely when you're unable to meet your child's basic needs, even if that's the child's basic needs related to poverty, then we would have a standard that would allow for the separation of far more children from their parents. And as we know in this system, it is very likely that that discretion will be used in ways that will result in the disproportionate separation of children of color from their families. I'd like to make sure that my colleagues drove me. Sorry. Thank you.
Thank you, Councilor.
May it please the court. My name is Moses Okeo. as someone who grew up in Kenya during the beginning of the Somali conflict, who grew up with Somali refugees as neighbors, I'm humbled to represent the father in this case. At disposition, family separation is an exception, not the rule. The court found dependency because the mother was the dangerous circumstance that would harm the children's psychological well-being, and the father needed to be sufficiently protective force and not to allow her unfettered access to the children. At disposition, the father proposed a plan and agreed to in-home services that would adequately protect the children from the mother. To address the court's concern that he would allow mother unfettered access, he presented evidence that he secured family housing, walking distance from the children's school, staffed 24/7, video surveillance, strict no guest allowed policy. Mother could not gain access if she tried. He proposed parenting coaching in the home so he can learn skills to support his children from the trauma of living with an unwell mother. He secured transportation to and from school, an after-school program for the children for when he worked late. This father was present at the court's disposal, willing, asking to be allowed to care for his children. Yet at the disposition, the court rejected his in-home placement plan on the basis that returning the children would set him up for failure. The court removed the children because their father lacked basic child development skills. And this was sufficient by a preponderance of the evidence to hold that he was not available to care for them. This court recognized in KW that dependency proceedings are already vulnerable to cultural and racial bias. In King County alone, the Black population is 14% of the population, but made up 36% of dependency cases in 2020. The department is really asking for the court to adopt a broad definition that is harmful, that will swallow the rule. Adopting such an amorphous legal standard like the department is proposing and adding a preponderance standard to boot would make judgments even more prone to racial bias. Under our plain reading, available simply means present, at disposal, obtainable. And even if the court disagrees with us, our understanding, the Court of Appeals offers the next best interpretation, requiring a clear, cogent, and convincing evidence before a court can separate a family under subsection A. And that interpretation is required, as Amici is pointing out, that family separation touches on the core right of family integrity for both parent and children.
Can I ask you a question then? Do you read the statute, the pieces that perhaps preponderance of the evidence would apply to be, I think what Ms. Ers called the yes or no questions, the readily apparent? Like, is someone physically available? Is someone willing? That it would be fine to have a preponderance of the evidence standard as to those basic determinations?
Amici argues that they need a standard because it's self-evident, shouldn't be contested. Either the parent is present at the court's disposal, or if they're not available, means they're dead, in prison for life, or their whereabouts are unknown. So at the court hearing, the parent is either present or not present. And if the parent is present, they say they're unwilling to care for their children in B. And if they're willing, you go to C. Can the department prove that the children will be in manifest danger if they're returned home to the parent by clear, cogent, and convincing evidence? And this is the reading of the plain text reading. At disposition, the statute presumes the children will be maintained at home if services can adequately protect them in the home. There are only 3 exceptions to that rule: if the parent is not available, the parent is not willing, and if there will be some manifest danger at home if the children are returned home to their parents. At disposition, the court used an overly broad, vague understanding of available to separate these children from their baba. Without a clear legal standard, the goalpost always moved to something else. The department did not have to show a specific harm to the child. The court held he was not available because he did not have the skill set yet. He was not prepared to be the sole caretaker of the children. He needed to learn some basic child development to be prepared. With such an amorphous legal standard of available, the court was left to rely on mental shortcuts or subjective opinions. Is the parent sufficiently ready? Does he have the skill set? Is he consistent enough? Such amorphous legal standards makes judgments prone to cultural and racial bias, as happened in this case. Lacking skill set, not prepared to be a sole caretaker, lacking basic child development skills, are mental shortcuts based really on racist tropes of an absent Black father. But this father was not absent. He was present. At the time of the disposal of this disposition, these children were 11, 9, and 6. He had cared for them before by himself in Minneapolis. He had cared for them a week at a time on several occasions when he visited Seattle. The department claimed he could not provide his children's basic needs, but he showed he could. He moved to Seattle, got a job, worked overtime to provide, got housing. The goalpost moved to something else. At disposition, the department claimed he called his children past their bedtime, which meant he didn't understand child development.
Counsel, you have gone past the time, but please summarize the readings that you request from the court today.
This court should reject the department's broad definition of available. It is harmful and it makes family separation the rule rather than the exception. This court should protect families from unwarranted separation, first by narrowly defining what it means to be available, and second, by requiring the department to prove by clear, cogent, and convincing evidence that removal is necessary to protect children from manifest danger in the home. Thank you.
Thank you, Counsel. Rebuttal, please.
The issue of demeaning the term available is not properly before this court, but if this court chooses to address it, it cannot be that it means only physical presence. And changing the definition of available and limiting it to this degree would have significant impacts in child welfare proceedings, where children would be returned home to dangerous situations, where there is extensive emotional, physical abuse that does not meet the definition of abuse because there is not.
Counsel, I have a question in regards to the disposition order, if you can just answer it for me. The RCW subsection 6A in the dispositional order appears to have additional language. And I notice it says there is no parent or guardian available to care for the children and then goes to subsection B. After subsection B, it goes and or. But when we look at the statute, that and or isn't in there. How does that play into our analysis and how we view the statute? And is there an error in regards to this dispositional order?
And you're correct, Your Honor, that the dispositional order adds language that is not within the dispositional statute itself, but that is consistent with the plain language of the statute, and that at least one of these three bases must be found to place a child in out-of-home care, but there can be multiple bases supporting the out-of-home placement. It cannot be that subsection A, that a child can be placed in out-of-home care under subsection 6C when a parent is present in the courtroom, because this would mean that children can be placed in out-of-home care only upon this manifest danger of serious abuse or neglect by clear, cogent, and convincing evidence. And this is a higher harm than is even required to terminate a parent's rights permanently, which does not make sense within the context of 1334 proceedings. We also have guardianship proceedings where a preponderance of the evidence standard applies, and this court has determined that that's constitutionally sufficient. Subsection A is not overly broad, while it does have admittedly a somewhat subjective whether there's deficiencies that impact the child's health, safety, or welfare. There are multiple steps that a court must reach before it gets to that question. The child has to be dependent, which means that the parent has a deficiency. The court then looks to 130 subsection 1. It can order two types of placements. One, in-home with services that ameliorate the safety risk to the child, or two, out-of-home care. So the court must make these findings. And additionally, the department must provide reasonable efforts and offer preventative services in an effort to keep the child in the home. And it is only when these things do not adequately protect the child that a child could be placed in out-of-home care under subsection 6A. And to be clear, poverty would not allow a child to be placed in out-of-home care under subsection 6A, as poverty is not a deficiency. And there must be a deficiency that threatens the child's health, safety, and welfare.
Do you acknowledge that under your reading, A becomes huge and C becomes small? And under the reading that father advances and amici support, I guess A would be quite small and C is where all the analysis occurs.
And Your Honor, C would remain very small. It is very narrow by not only those narrow definitions of abuse and neglect, but also serious abuse and neglect and a manifest danger. And again, the reason why the legislature included these requirements is because subsection 6C is not limited to the parent's actions. A child could be removed from a parent's care due to someone else in the home, and that's why the legislature imposed this higher burden. As Chief Justice Gonzalez had asked, there have been several legislative amendments in the past at least 10 years since courts have upheld this meaning of available. None have changed the standard or the definition of available, even after House Bill 1227 that raised the showing of harm for a child to be removed at a shelter care proceeding. Subsection 130 has remained the same. The legislature intended that when a child is faced with placement in a parent's home that jeopardizes their health, safety, and welfare, that child be the primary concern. Their health, safety, and welfare is of paramount concern to the court and be placed in out-of-home care. The department asks that this court reverse.
Thank you to counsel for your briefing and argument. The case is already submitted.
All rise. The Supreme Court is adjourned.